remember which one to carry on with.
Okay, as we've sorted that out,
Sorry, did you mean the question 3?
Oh, sorry. I beg your pardon. Oh, sorry. We can do it now. Sorry, they want to do question 3 first.
I want to do this one first.
Yeah, we did do, it was just, yeah, we did look at it yesterday. It was just point, we just need to clarify points 3 and points 8, isn't it? The rest, I think, is absolutely fine, and that was the charge covenant. Yeah, sorry, that's why I wanted, that's why I wanted to. So that's what we wanted to do first, if that's all right with you?
Yeah.
And then on to complaints.
Yeah. Okay, so we're just dealing with those 2 points.
Yeah, just those 2 points, not the others.
The issue of this question is that whilst the rule, and which is a wonderfully simple, is that he was first in point of claim, first in point of time is first in point of claim. I can't remember what the Latin is, but anyway. Yeah.
No,
I've got it written down somewhere.
The general point principle.
Yeah, that's the general principle as to how registration and priority claim against assets works, with one massive exception in the realm of charge covenants, where, notwithstanding that, and that the circumstance that's described here is that the original owner of this building divided it into 2 flats, he kept one, he then enters into the charge covenants, in that document, fine. But at the time he sold, he was still indebted to the wonderfully named Binkley West Bank. He then later gave a further bond in favour of Goodley. Yeah, I'm just getting the facts in my head.
Sorry, I sprang it on you.
So, and then it all starts to go wrong. He's not maintaining the premises, or rather, he's not contributing to the cost of maintaining the roof. In the intervening time, he's obviously got into debt, and some plumber has got a judgment which has been registered against him. So there are, charges stacking up against him and his ownership of the flats that he obtained. Question is, under the terms of the charge covenant law, what's the consequence of all this happening? Now, there's the first important point which I hammered home yesterday is that the claimant in a breach of charge covenant matter must, and it's absolutely mandatory, must make sure his claim is registered at the correct stage of the proceedings, which is very fully outlined in the guide. It's section 9 of the law. If he fails to act correctly at that point, everything I'm about to say goes out the window.
So is he not, so say, I don't know the law, but say he has to register it at point A,
yeah,
and he doesn't do it,
yeah,
6 months or 8 months later,
yeah,
is he completely prevented from relying on the charge covenant to point A to appear us? The only point of time, if he registers it 7 months later to get it at that point.
No. It is on the day of the tabling of proceedings.
As good as nothing.
Correct. Yeah. Yeah. He's still got a claim, but in terms of his ability to take priority over other claimants, gone. He's at the back of the queue now. Fatal. Absolutely fatal. But we assume he's done everything correctly. In fact, the facts say on the same day, that's really key. On the same day, he causes a note of his proceedings to be registered in the Leave Daisy Protect. So, where does that leave him? Well, the power of the charge covenant is that by following that procedure and doing as the law requires, the prior claimants or registries against the defaulting owner's apartment, which are Goodley Bank, £50,000, and John Oger Plumbing Services Limited in another sum of £50,000. Notwithstanding, they were registered literally years before this all happened. So in the normal scheme of things, they're first, they're ahead. Suddenly, they're behind. But here's the twist. To continue to give effect to the underlying principle of priority, what the law didn't do was say that a creditor who had a claim against the person who gave the charge covenant. So at the date of its creation, which was the 6th of May 2006, John Martell, the vendor, was indebted to Binkley West Bank for 170,000, which the facts tell you had been registered on the 25th of April 2003, day after he bought the whole building. So, because of the way the legislative scheme is set out, that remains a prior charge against John Martell's asset, which is the apartment. So what this question is getting at, in fact it asks you specifically, lists the priority of charges. And so it's making sure that you have understood that whilst the law has given, Ronald, priority over Goodley and John Oger Plumbing Services, he won't get priority over Binkley West. In all the circumstances he would have, but not because of that.
So it's regardless, what I was sort of thinking about yesterday, and it might not be happening, but you start, so in these circumstances here, say he sold the property, he made the property charge covenant 20 years ago.
Yeah.
Yeah. But you've got all these priorities, you know, the bank, the judgment debt, all of those coming and being registered against the property. The obligation to repair he's been doing for 18 years.
Yeah.
Yeah. It's only in the last 2 years, which is later in time than the other charges against that property.
Yeah.
So he's in default of his charge covenants.
Yeah.
For those 2 years.
Yeah.
So I have to issue proceedings against him.
Yeah.
Because the repairing obligation is only the last 2 years, does that still go back to the charges?
Everything.
Because it's in the charge covenant, isn't it?
Everything.
Breaching a charge
It
covenant
trumps-
goes back
it trumps
to
It trumps everything. That's why once you
pretty
begin to
powerful, aren't
understand
they?
it, you think, my God, that is immensely powerful.
Yeah, they are immensely powerful.
Yeah.
Anything other than
Unless it had that charge was there before the original charge covenant. No, because, and it also fits in with that principle you also, I presume, if you've looked at it, would have seen in Albany versus Wrench, where Richard Collis analysed the power of the court to, when allowing registration of a judgment, to amend the registration. And Jeremy Le Tissier was trying to persuade Richard that included the powers of alter priority. And Richard said, no, the power that we've got there is we can alter the amount. We could perhaps alter any specific terms of the court's judgment in terms of the registry. What we cannot do, and would have had to been set out in such clear and unambiguous terms in the law that there was no doubt, is we cannot alter priority. The Royal Court has no power in any circumstances to alter priority. That is effected by registration. It's key, it's paramount.
How do you get round then charge, so if you put so I own a flat, like it needs to give it so say these circumstances that the flat's created out of one building.
Yeah, it's a converted building.
Converted building, yeah. And someone bought the whole thing around it.
Yeah.
So the charge covenant is created later
Than the original
than the original
loan that bought the building.
Yeah.
Yeah.
How sort of like later purchasers, because it's a lender not going to be concerned. So I'm a new purchaser of that flat. My charge covenant is going to be earlier than my
Yeah.
bond. How do lenders?
Generally speaking, they
Is that right? Right, the lines.
yeah,
No,
you're spot on. Lenders tend to take a commercially pragmatic view, which is that the likelihood of these circumstances arising are sufficiently remote that it's worth a punt,
Yeah.
as it were.
Would it not also benefit every other flat owner, the person that their apartment, right? They also have the same obligation. So that if the roof is falling down, the owner, the person, their borrower,
Yeah.
and then make a charge for it.
Well, they
Actually, that kind of protects the asset as a whole.
well, exactly. So they look at the whole thing, not just their own loan in isolation. And yes, there's a little bit more risk involved. What you'll discover in practice or in the commercial world is that I couldn't tell you where the threshold is, but with most commercial lenders, I am aware that when asked to advance money against the purchase of an apartment where there is a charge covenant, they generally set the threshold of the loan to value ratio slightly lower.
Oh, I see. Yeah.
So what they do is they discount it slightly
Yeah.
in money terms, so
Yeah.
they've bought off some of the risk, as it were.
Yeah.
So whilst for a house that doesn't have any charge covenants related to it, they might be prepared. In fact, 100% loans are now back on the market, which is terrifying. Again,
Yeah.
Really?
Yes.
Really?
yeah.
Who's doing that?
I'm sure it was Barclays, and there was one other lender, one of the newer kids on the block, the disruptor banks.
Yeah.
Ra.
God.
However, we haven't seen any of them go through because when we read all the terms that you had to meet, they were so tough, no one was ever going to meet them. So it's a nice bit of advertising fluff. But generally speaking, historically, I have recollections of some of the more cautious lenders saying if you're buying an apartment, we will not lend on a loan to value ratio more than 80%. Some of them would go up to 90, and I never heard of anyone who went to 100 because they know there's a charge covenant. There's a little bit of extra risk that the bank might have to dig their hand in their own pocket to get something done or get them out of a jam. So they price it that way.
So just going through the priorities again, so just we've got one that we know is correct.
Oh, Heidi.
Right, so the properties,
Binkle West.
right, Binkley West is first. That's it.
Is it Ronald's is next? Is it Ronald's?
Then it will be Ronald's.
Then Good.
Then it will be Goodley.
Goodley.
Then it will be John Osier Plumbing Services.
No, there's James, isn't there?
Oh, is there one?
I thought there was another one.
Oh, I'm sorry.
Going
Oh,
bonkers,
yeah.
yeah. Then there's James.
I
Then
was
there's
sailing past that.
James and Ogier or whatever it's called. John.
No.
No?
No, it's Binkley West,
Yes.
Goodley.
Goodley.
Oh, sorry, but
Why
Binkley
not
West,
Ronald?
Binkley West, Ronald,
Goodley.
Goodley. Yeah, James. Bill.
James.
Yeah.
Yeah, and then
And then John
Ogier.
Ogier.
Is that right? Yeah.
Yeah.
Okay, that's fine. Oh, sorry. What is it called, John?
Osier Plumbing Services. It's Osier Plumbing Services.
Using science coming from there again. Okay. Yes.
Basically, it's
Yes.
West is their creative person.
Yeah.
Because the bond is created before the creation of the charge covenants. Ronald, because charge covenants trump the other matters. God leaves them then next in time. James, because of the point about his judgment, the date of judgment is on the leave rather than the date of judgment. Mary just
Yeah.
Yeah.
Yeah. Okay. And I think we better move on to conveyancing. Sorry, I need to move on to conveyancing. I don't know how you want to. There's so much to go through. I don't quite know how we're going to do this. I couldn't get it straight in my own mind before I even came here. I did a few problem questions and I thought we could use those. Yeah, but it's just leases. I don't know where to get any more information on leases, so I'll talk to you about that.
The best thing is, have you read Simon Howitt's article about 2000?
Is that in Guernsey and Guernsey Law Review?
It is.
Oh, I haven't read it.
2002, 2003.
I haven't read that. That's
About
fine.
registration of leases.
Oh, I haven't read that.
It's very good because it deals comprehensively with leases and registration.
Okay, that's good. I don't know whether you want to.
Sorry, no, which example have you got?
Well, I don't mind. I don't know whether you want to give them an overview of the conveyancing. I really don't know how to approach this. And then go on to some past papers, but it's very much, I'm very much in your hands on this one, you know that. There was such a large volume of this that similar sort of things crop up time and time again, I think. We could, hold on, which ones have I had a look at? I don't mind having a look at some that I haven't had a look at. May 2012, where's that one? Question 1.
2012.
Yeah, I mean, that's a conveyancing question. There's also May 2010, question 3. But the same issues tend to arise there as in question 1 of May of 2012. So it's probably better to just do the 2012 if I can find it. Yeah.
May 2012.
Yeah, question 1, I think. I don't know. You happy with that one to start off with? Up to you.
Question 1. Which question is that also similar to?
Yeah, so that's quite a. There's a lot there, but 24 marks.
I know, that's why I chose it. You know, I'm not choosing easy ones, John. Whatever you think of me, I do not choose the easy option. There is quite a lot here. Yeah, question 1. Vincent and Violet. And I thought, indeed, there was a lot there.
Yeah.
What question did you say that's quite similar to?
There were bits on this that were similar to the immunity. Yeah, the immunity certificate stuff, which I also prepped, but I don't see any point in doing it twice. Question 3, May 2010. I can't remember how many marks they awarded for that one. 2010, hold on, where's it gone? I can't find that one. They were awarding. Oh, 22 marks for that.
Similar.
Yeah. So I thought question 1 had more in it, I must confess.
Yeah.
But so that's fine. But it's up to you.
Okay. So we're looking at May 12, question 1, part 1.
So look at the conveyance.
Yeah.
What's wrong with it?
Well,
In a sense, yeah.
sort of, yes.
Yeah. You get the examiner.
Yeah, that was what the first bit was really about. Sort of.
I mean, Simon does say in the facts, you haven't personally had the opportunity to go through details of title. So he's not asking you to concentrate on title, but look at the drafting errors.
Yeah.
Given that we don't really teach drafting in this
Oh.
course, that's a little bit. But anyway, let's quickly look at it.
Well, you can look at the minutes there.
Yeah, no, yeah. This is your drafting list.
Sorry, I assumed because it was on the page, I was assuming that.
Well, yeah, this is that. Right, okay, so let's look at the complaints, which is appendix 1 at the back of the paper. Now, I suppose I'll give you 2 minutes on the basic structure of what we call a conveyance. What you see before you is not some approved or rigid form that has to be employed by every advocate. You would be surprised the latitude we have as to how we present a document which we now commonly term as a conveyance. In 1969, when we changed from French to English, all the beautiful classifications and subdivisions of contracts that formerly existed disappeared, and they were all subsumed into the bland English word conveyance.
Why was it changed? Because most people not speak French.
Yeah,
Society's changing, isn't it?
it was, you know, the usual, well, you know, society's changing. The majority of property owners in Guernsey no longer have French as a first language. To be fair, even my parents would have struggled to read a French conveyance because it's good French, not Guernsey patois. And it's archaic good French.
Yes, yeah.
So, you know, that's a credible argument as to why it had to change. And the idea was that, you know, notwithstanding that advocates are specialists in the law, there was no good reason why they had to defend that specialism by means of using archaic foreign language.
Can you use French if you want to?
Absolutely, yeah.
Isn't apples?
Traditionally, if I was conveying a fief, I'd do it in French. I would never do it in English.
Okay.
Yeah. And up until 2000 and what was it? 5? Off the top of my head. In Sark, we still did them in French. It's lovely. Great fun. But there you go. So the background is that it's not an English conveyance. I would prefer it if every single document I placed before the contract court began with the words, this contract. Then I'd feel so much happier because that's what I'm doing. It's contract. It was a special thing. Regrettably, use of the words has caused an awful lot of angst and argument, which is great for legal fees, as to the meaning of words and phrases in the document. Cobblers. It's all about contract. But anyway, so it starts with this conveyance between. The first little section there, which he happens to have numbered 1 and 2, we would commonly describe as the opening parties. So we look at, okay, the vendor is said to be, and remember you haven't looked at titles, so you don't know whether this is correct, but we're going to just assume that that's not relevant for the purposes of this. Ronald's Hotel, you'll notice he is described as son of Wilson George. And that is the same for the buyer. He's Vincent Plummer, son of Richard Henry. Now, if either of those persons were female, they would be described as, if say it was Violet, she was born Violet Videlow, it would be Violet Videlow, daughter of. And people say, why'd you do that? Well, it's because of registration. There was at least one other John Letizia with exactly the same names as myself, and I mean exactly the same, who died about, I don't know, it must have been about 15 years ago. And a few people didn't twig that he was 72 when he died. I wasn't 72 when he died. And, you know, there are a couple of phone calls from people, sort of, you know, oh my God, John's died. Because it's the same name. When you go searching in the graph and you're looking for a specific person and you come across their name. Now, remember in the graph, everything is registered under person's names, not properties, names. And you find a name and you think, great, found it. And you look it up and you're thinking, this is weird. seems married to someone else, and you know, at the same time as I know he was married to that one, and oh my God, he's a bigamist. And the way we distinguish it is, although it's not impossible, it is unlikely that their fathers would have identical names. It's just a way of weeding out people from the searches. And you begin, and it's also that relic of connection, family. Family is important. Your patrimony, as it were, which comes down from the line above. So we correctly describe Ronald Tuttle, he's son of Wilson George, that's where he lives, blah, blah. Refer to him as conveyance as the vendor, which expression shall, where the context so permits, include his successors in title. Oops, first mistake.
Yeah.
Should say
Should
his
say
heirs.
Yeah.
Vendor.
It should be heirs.
Right, so purchaser is always
No.
successors in title.
Yeah. And
Vendor is always heirs, although if you are selling as joint owners, it would be, which expression includes the survivor, exactly if they've got it here for the purchasing parties, where the context permits includes the survivor of them and the heirs of the survivor.
So say again, vendor is always heirs.
Yeah.
Yeah.
Purchaser.
Always successors in title.
So we've got this the wrong way around here.
So that's
Yes.
the wrong way round.
I'm pleased I got that right. Sorry, I shouldn't say that, should I?
And from a drafting perspective, just so you put it into context, the reason we say the vendor includes their heirs is because, remember, this is simply a contract. It's a contract which contains promises. One of the promises is the guarantee of title that we'll see hopefully later on. I haven't turned the page yet. Yeah. Yeah, okay, that's interesting. But there is a guarantee of title later on. We'll talk about that. Something not quite right there. And the reason that the vendor is for themselves and their heirs is they are making this promise on the obligation of themselves and their heirs.
This is successors. Oh no.
So it's actionable by the purchaser. Hey, you gave me a warranty as the title. It turns out to be false. Or,
Because his heirs.
and in the meantime, you've died.
Yeah.
But I'm going to sue your heirs because you gave me a promise.
Yeah.
That's why I just that's why
It's
But I think what I was going to ask the question is, why is heirs different?
well because the vendor is merely promising, giving a personal promise. So what he's promising is a promise in personam. The action lies against him and the heirs to his personal estate.
Okay, not
The purchaser is accepting the vendor's claim to title. So he's accepting everything for himself and his successors, because this is an estate in perpetuity, an estate of inheritance. It's absolute. Incidentally, if you were conveying a droit de usufruit, you wouldn't say successors in title, because there aren't any. You're just buying for your life.
So if you're conveying a what both of those is the one that happens.
Yes, if you're
and not a usufruit then.
if you're conveying a usufruit
Well, yeah.
or droit de possession, then of course it's not an absolute estate of inheritance, not in perpetuity. So you don't have any successors in title. Nobody can succeed you. Yeah, it's limited to your personal life. Now, although strangely enough, you can convey that, the person takes it, and you can convey the usufruit, the person takes it subject to your staying alive. So again, it's still not perpetual. In a sense, that sounds more like an assignment if you can think about it that way. Anyway, let's move on. Next clause, clause 1. This is the habendum, the most important clause in the conveyance, because we've already looked at the tensions that can arise between joint owners, owners in common. How do they go about describing what they've accepted? So Ronald conveys for an estate of inheritance, that's good, we'll see that, to the purchasers. All those premises, brief description of the premises, situate Ricta Cutter in the Palestinian people on Fief Loire. In your study guide, you will note that you have to name the fief if it's on a fief. What do you think might be missing from the habendum?
How it's vested in the purchases because they're joint, whether it's joint.
Yeah.
or-
Yeah.
So the frankly absolutely rubbish clerk, they'd get a rocker for drafting anything like this, has put the words that should be in the habendum in the description of the purchases.
Yeah.
So that's where those words should appear. So it should be saying after the word purchasers, accepting for themselves the survivor of them and the heirs of such survivor.
So after the where, sorry, you
Where it says the vendor hereby conveys for an estate of inheritance to the purchasers.
Yeah.
Now, those words are pretty consistent in every single conveyance, no matter who's drafting.
Yeah.
And then you state what the vesting is. So you say accepting for themselves. That could be, as we've got here, for themselves, the survivor of them, the heirs of such survivor, or it could be accepting for themselves and their respective heirs in undivided whatever shares you want, or such other sophisticated vestings as I've alluded to. That's where the magic happens. That's where you pin it down. Very briefly, let's just think. For whatever reason, you had a bad day yesterday. You had a bit like me last night. You had a few too many gin and tonics. You're not really seeing straight. You miss the fact that that's wrong. Contract court is tomorrow. You've got to get this approved by the vendor's advocate engrossed and all ready within the next 3 hours. You miss out the fact there's no vesting. The conveyance is completed in court. Still nobody notices. Nobody spots it. The conveyance is completed. Everyone's happy. Mr. Tuttel's been paid. You've registered the conveyance. And then Vincent comes to you later on saying, we bought that house, we've been having a few marital difficulties. And we thought, buy a new house, change of circumstances, change of scenery, hasn't worked. We're splitting up. What's going to happen with the house? I mean, now I want it all because I spent most of the money. And you think, well, hang on, let's just check the vesting in the conveyance. Oh my God. So what do you think? How they hold it because of those missing words? Everyone happy with that?
That's what I would have said, but it doesn't sound.
Absolutely spot on.
Yeah.
Ownership in common.
Ownership in common, not.
Ownership in
Oh,
common.
yeah.
I thought
Ownership,
if someone was deemed.
that is the default position.
Oh, okay.
Yeah.
Well,
Ownership in common in equal shares.
So you've got to put something in the conveyance if you don't want it in common. You've got to get it
In the
to work.
exactly.
Yeah.
So it's not just finance. No.
Mm.
This is the. So if he'd have died, so say that they've died, whatever, that would be the.
And that may cause some real issues. Yeah. Yeah, because if their wishes in their instructions to you as advocate have been, we want it joint with the survivor, You're looking at professional negligence if something goes horribly wrong. Then the conveyance conventionally deals with the boundaries. It gives a clause laying out the boundaries of the property. Now, just to explain, if you look at the very, very old conveyances, I'm talking early 18th century, they rarely have boundaries. Because fundamentally, why do you need them?
That's usually it.
Well, exactly. Fundamentally, though, you don't need them as a matter of law. You could take the boundaries clause out of every single conveyance. It would not impeach the title in terms of making it defective at all.
It's only if you have to determine there's a dispute about what the
It's
insurance
probative value. That's all it is. Because if you go back to the whole concept of, well, what is a title in Guernsey law? Why do we own, how do we own something? Possession. And it's really very basic and very pragmatic. When you're standing there on site, forget the paper, when you're standing there on site and you're saying to someone, well, what do you own? Well, I own this. Now, if you're standing in a, you might call an urban property with granite walls on all four sides, it's pretty easy to understand what they're in possession of. If you're in the countryside and there's, some brambles and some trees and you can see a bit of stone wall, it gets a little trickier sometimes to work out exactly what they're in possession of. And in fact, there was a recent case, which is a professional negligence case, which was against AFR. And you will see there, the solution of the Guernsey court always is a vue de justice. The jurats went out, but the advocates made strident representations about what was in the boundaries in the conveyance, and it said this and it said that. There was a plan here, and the jurats went out, took one look at what they saw on site, and just applied common sense and said, well, you must have been in possession of that. That's obvious. But that bit over there, no, it wasn't obvious. Bingo. So you keep coming back to looking at the property on site. So the boundaries, as I say, are in the conveyance because they are a useful summary of what somebody saw and a way of recording, as it were, how the property evolves. You know, in one conveyance, you'll see the description of the boundary is formed by some granite boundary markers and a wire fence. 25 years later, you go down and, whoa, the wire fence is gone. Not surprising, it's probably rotted. And they built a nice concrete block wall in its place. Nothing wrong there, but it's just different, and it tells you how the property evolves. People think of title being as some static thing that never changes. It's constantly in flux. So here your clerk has set out the boundaries. They're conventionally set out by reference to compass orientation and in a clockwise direction. You always start with north, then you just go clockwise, east, south, and what's missing here.
Doesn't matter though, does it?
It doesn't, it's not fatal to the conveyance. It's just sloppy drafting.
When they're in French, they don't necessarily go.
Okay.
Oh, sorry, we'll do it French. Sorry, I beg your pardon. Yeah,
I've
sorry.
got one of the French ones in the exam paper because we'll have a quick chat about French ones in a moment. This is it.
Yeah, sorry, I shouldn't have brought that. Sorry.
Right, so another thing to spot, no western boundary. Clause 3. Purchasers have the benefit of all rights in the servitudes and insofar as they subsist. Well, that's not wrong, but it's pretty pretty unhelpful.
Yeah. The servitudes clause is just.
Yeah. Now, let's ask ourselves also one other question, just so you have this clear in your head. Would it matter if the clause had been totally left out as a matter of title?
Well, no, if you
No.
weren't in servitude.
If servitudes had lawfully and correctly been created, you know, the conventional way, by contract, in court, registered. The fact that a subsequent conveyance forgets to mention there are any servitudes, does that affect that? No, not in the slightest.
Do you rely on the early conveyance?
So you rely, well, the point
rely
is, the
on
person
the-
It's been created,
Yeah.
so you can't.
It's been created, you
You can't
can't-
extinguish it by leaving it out.
No.
Correct.
And that's what you
Yes,
that is why if there are rights that says there are some, you without specifying them, apart from the fact you curse your fellow advocate saying what an incompetent Burke so and so was, you then are your clerk, or often in my case because they're not that good, I end up doing it myself. I'm in the graph hunting down, oh, how did this happen? Where does it come from? Does it still exist?
It's
What am
like
I
the old-
dealing
It's like the old, like, sort of root of title. Like, going back,
Sort of,
yeah.
yeah.
I think it's more intense than root of title, I must confess. I think it. What's the word I'm looking for? Because you don't have to bother with, you don't have to bother. I think this is more rigorous, let's put it that way.
Yeah.
Yeah, I think this is far more rigorous than root of title.
So whilst it's not wrong, the proper approach is, if such rights exist, declare where they came from. And I completely understand, because sometimes I make this decision myself, where you've got extensive rights set out in an earlier conveyance, you don't particularly want to sort of have to regurgitate them, you know, word for word. Having also, because remember they were created at an earlier time, so names will be different, and perhaps, you know, little descriptions will be slightly altered. You don't want to have to then sort of reinterpret them and regurgitate them in your conveyance, with the danger that you might get them wrong and then just give parties a chance to have an argument.
Yeah.
So often you would simply have a clause very similar to this, and then you'd add on to the end of it, and in particular as respects those contained in, and you specify the exact contract within which they were created. So, you know, when it was registered. And if you're a really good draftsman, you'd also say who it was between, and you will say between James LePage, predecessor entitled to the vendor. So it was a vendor's predecessor at that point. And then you'll say another name, predecessor entitled to, and in the boundaries you'd said Bournemouth is owned by Kenneth Osier. So you say predecessor entitled to Kenneth Osier. So straight away you've given a massive, big, friendly helping hand to a subsequent reader of the conveyance that, oh, there's some rights between La Hauteur and Bournemouth.
You just include them by reference to the
Yeah.
earlier conveyance.
Yeah.
And would you have that as with, like, you sort of type sort of within?
Okay, that's kind of procedure, which is,
Do you need them?
No.
I didn't think you did. No.
and this is, I had a bit of a battle with Simon when he was writing this, because it went into massive detail about how important it was to deliver the documents and muniments of title. I said, problems. I said, if it's registered, I take note of it. If it's registered,
Yes,
I found
I
it.
thought it was
I've read
registered.
it.
Yes.
And
Do you just like putting it within the document?
yeah, now in the days before photocopiers and PDFs and online, you know, hyperlinks, it was certainly jolly useful, and, you know, vendors earned the undying gratitude of the purchaser's advocate if they had all their documents and handed them over, because, oh, great, you just saved me 2 hours looking in the graph. But sometimes you didn't get them very quickly because somebody was on holiday when the offer had been made on the house, the agent didn't have them. Oh, well, no real matter. Once you've got some basic details, you trundle off to the graph, and within an hour, you've traced title back 200 years.
Is it very easy easy to trust her. Yeah, because I mean, that's what.
Well,
because it sounds.
it is, unless you have an intestacy,
God, where.
because you inherit
That's right.
the more.
That's right.
I'm doing one at the moment. I've been instructed to do a partage between two brothers who have inherited all their mother's real estate. But easier. She was a reasonably wealthy woman. She owned a house and a very large field next to it, a couple more fields, and the real sticky bit, a parcel of land, which is somewhere in the Goof Valley, just below the restaurant, if you've ever been there. So far, we've managed to establish that the brother's great-great-grandmother was awarded ownership of this parcel of land together with her sister, her mother, and her father under the partage of the Terre Communale de la Padua de la Forêt in 1834. I'm absolutely certain that their mother would have acquired an undivided half share because of the way the order in which the family died.
Mm.
The problem is the two sisters, the other sister seems to have left all her property to a cousin. But what's interesting is in some earlier documentation, this parcel of land is not mentioned at all. It's almost as if the family forgot they owned it.
Mm.
Although the two brothers tell me, oh, we know we own this land because our grandfather used to take us out there when we were children and used to point to that big pine tree up there by the cliff path and say, we own that land. So they said, we've always known we own it. The Kadash shows they've been paying all the taxes on it since at least 1924. But I'm struggling to pin down precisely how they own it. And that's your nightmare. Just pinning down an intestacy that goes back nearly 200 years. However, everything else tends to be a registered written contract. So,
which is fairly straightforward. Because I looked at this and it looked quite complicated. It looked as though you'd be stuck in the graph for ever and ever and ever. Just I couldn't quite work out how labour intensive this was.
If you're not very good at it, it
Then
can
you
take a
would,
while.
yeah. Yes.
Yeah.
But,
Oh yeah, you get better and better. And it has to be said, the new system where the online cadastre has each transfer with a link to the Royal Court website, and there is a PDF of the document that affected some transfer of ownership. And you just literally, I sit at my desk, and within a couple of clicks, I've got the document like that, in that form, on the screen in front of me. That costs me £3.50. You can download it, print it off, do whatever you want.
So, just thinking about the document, so with signing to you, is that just a matter of practice and your preference in his view that it is important to have all the documents?
No.
With that
From the day I started, many years ago, many decades ago, we were fairly blasé about being handed all title documents, because the point is you could go to the greffe.
Yeah.
And even if you were handed all the title documents, so what? You still went to the greffe, because you still had to do the search. You had to check you've been given them
The
all.
right stuff,
Yeah.
You know,
You
what,
just you don't rely on
correct. What's in the
Okay.
greffe counts.
Yes.
It's registered.
So it's enough in that service clause to just refer to the earlier documents.
Correct.
That's the type of stuff
Yeah.
you've seen them,
Yeah.
et cetera, and
Yeah.
then,
Yeah.
you don't have
No.
to incorporate it by reference.
Exactly. And certainly when you are, this one isn't dealing with it, but if you were dealing with, by way of example, an apartment in an apartment building, if you were to look at an example of a modern apartment building with a comprehensive schedule of rights, obligations, covenants, you name it, they will easily stretch to 28 pages of single-space typing. They're big documents, they're complex. You don't want to regurgitate all that in your little conveyance, especially not when you're conveying an apartment. I mean, it'll bump up the cost of registering your document by about 60 quid. So you don't do it. You
It's
just
charged per page.
per page,
Mm.
£4.50 per page. No, sorry, it's £5.50. It's gone up. Yeah, they keep pushing it up. So, okay, that was slightly wrong, but all right. And of course, we're not creating any new rights between Ronald and Vincent and Violet because he's selling everything he's got. Of course, if he was retaining some land, you'd be asking the question, oh, does he need to reserve rights? Do we need to have them granted to us? Otherwise, we're into those awful destination de père de famille situations. Right, so the next clause in the conventional order sets out how did Ronald get his title to this property?
Is that the no title?
Well, like I say, there is no conventional way to draft a conveyance. You will find actually a few offices use a highly complex drafting method. I'm not going to say which one, but there's one which is particularly known for it, which uses extensive recitals. Personally, I'm with a couple of High Court judges in England who have trenchantly criticised this modern way of drafting because you splurge all these intense facts at the beginning of the document, which you then wade through without understanding why they're there. You then begin to read what the document's about, and straight away you keep having to turn the page back to see what they're talking about. Now, in a very, very complex schedule, that's the best way of doing it. In a simple conveyance, it's a bit over the top. But you would, yes, use recitals in where the circumstances make it easier. Use recitals.
You do need to mention or look as to whether the Richard had a wife.
Well, generally speaking, I think you could say that that is an utterly inadequate recital of title. And because it's disappeared out of my head, I can't remember when. Oh, that's good over. Think about the date on which Richard Henry Tuttle died. There's a big clue in there.
That's to do with children, whether he had any illegitimate children.
So is intestacy relevant? That's the point I'm trying to make.
His children,
Well, this is where a bit of succession
yeah.
has leapt into this question. Okay, I'm flagging up something in. Okay, correct me if I'm wrong, but this is obviously after the law that introduced the administrator of real estate, the intestacy provisions, 2009, because that came into force. What was it, 2008, off the top of my head?
I think so, yes.
Right, so
Yes.
now, whilst prior to the coming into force of that law, of course, there was nothing you could do. Intestacy was intestacy. You had to buy directly from the person who said, I am the only heir. And your only recourse was to say, okay, I'm going to go and search at the graph against well, straight away we've got a problem because it says here he's the only child and sole heir of Richard Henry Tuttle. However, in the opening passages it says he's the son of Wilson George. So either Wilson's wrong or Richard's wrong. Something's wrong. But whoever he's claiming to be the sole heir of, you, prior to the new law, you'd have had to go to the Grefg and basically search against his father's name to see were there the births of any other children registered to that man. Of course, if they were illegitimate, they'd have probably been registered in the name of the mother, so you'd never pick them up. That was one of the problems with intestacy.
Oh, I can see why the error's crept in.
Yeah, could
It's
be.
gone.
Yeah.
It's.
Yeah,
He's you know what I mean. Yeah. He's confused the purchasers and the
And the vendor's fathers.
father. Sort of. That makes sense.
Yeah.
That's why that's crept in.
However, what's really wrong here is if you were allowed to get acting for a purchaser from an intestate estate, ever since the new law came into force, you would invariably, I can't think of circumstances where you wouldn't ask for this. You'd instantly say, I'm not buying directly from the heirs because I run the risk.
Yeah.
There is an unknown heir out there and I haven't acquired their share of this property. My client's got a defective title, so
Yeah.
I want an administration order granted. And I will buy from the administrator who, under the terms of the law, has an unimpeachable title to any purchaser at arm's length in good faith.
So if you're acting for the purchaser of an intestate estate, then that's
After the coming into force of the,
after-
is it the 2006 law?
Yes.
Yeah, it's
Came
2006.
into effect.
Came
in
into effect
2008.
in 2008. It was delayed for
Yeah.
a long time. Yeah. So big red flag in that one. Then we have a consideration clause, notwithstanding that our contract doesn't require, law of contract doesn't require consideration, it requires only cause. We always declare what the price is, mainly so that the states of Guernsey can levy duty on it.
Yeah.
They're very, very keen
Yeah.
on their duty.
Yeah.
Makes them a lot of money. And just, it's nothing to do with drafting conveyance, let's throw a quick one out there. Is that necessarily the total price that the Vidamores are paying for the property? Contents, yeah. Which is nothing to do with the conveyance or the payment of duty.
And I presume you can. What was I going to say? I was going to say fiddle. That's the wrong word. I presume you can use.
No.
No. All right.
No.
I was. You haven't even heard what you don't
I know
know
where
what
you're
I'm
going with
gonna
that
say.
one.
You know what I'm going to say, do you?
You presume that you can inflate the value of the content.
I was indeed going to say that. No. Okay.
Ooh. Not now.
They will catch you, will they, on that?
Well, it's not that they'll catch you, but the point is that the way the document duty law is phrased, it's a criminal offence.
Oh. Right. Okay. Now you fiddle a bit more in England.
Yeah.
So I shouldn't say that, but you can be more creative with.
Well, over here,
Or you hate you break.
That's right. Yeah.
Yeah.
That's right. In order to bring you below certain stamp duty values.
Over here, that certainly was the case until the new document came in. And then because it introduced this new criminal offence of
That's nasty.
knowing or recklessly having reason to believe something's not right is a criminal offence, straight away the whole of the legal profession was dragged into potentially being liable if they, having seen
The French looks worse.
well, they don't-
Yeah, I don't think you can be too inventive, but
No,
you
no,
can
no.
be. You can do contents and bring it below standards.
but yeah, you get the minister self-contract, you get the inventory from the estate agent.
Yeah.
And there are no kitchen goods, a few threadbare carpets and curtains, a couple of bare light bulbs, and apparently they're worth £18,000. No,
I don't know how you knew what I was going to ask there, John. I'm rather worried. Let me see me in that light. Right.
So yeah,
Okay.
right. So there we are. We've got the situation. That causes fine.
Yeah.
The vendor acknowledges receipts there and then in court, although strictly in practice, we ought to hang over a huge bag of cash. We don't, because settlement takes place during the few hours after, which is a whole problem area, which I won't go into.
Yeah, I think it's weird, it's not like a system of clear funds.
But even clear funds never move straight
They
away.
don't.
You wouldn't complete in England.
Yes, but you don't hand over the funds until you've got. Well, in England, they go through this mindless exchange business
Yeah.
where everyone's sitting around phones.
Yeah.
Horrific,
Yeah.
stupid. In fact, we've got a meeting of the Property Bar subcommittee on Wednesday, and it's going to be, I think, what could be described as a lively discussion, because I've proposed some changes to the way we operate the conveyancing procedure, and a possible approach to the Royal Court to enact some of the orders they have the power to make under the 1987 Real Property Law that will allow us to do or make some adjustments to the procedure that make it far easier. One of the problems with cleared funds, incidentally, is where you've got a client who's got cash in his pocket, it's dead easy. You tell him, right, you have to give me the money 48 hours before contract day. If I don't have the money from you by that point, and I don't have it when I walk into contract court at 9:30 a.m. on the morning completion, you are going to be in default. I am not your banker. I'm not going to make good the money and wait for it to arrive from you.
Would you sorry to interrupt that. Would you take cash from a client? Because
Cash, no.
No, right. No, when you said money, sorry, that's what I mean. When you said money, I beg your pardon. I thought you meant somebody sort of had a bag of money.
No.
No, because you wouldn't be allowed to do that. No, I just went right. Sorry, John.
No, so you said I have to. However, where, and this is the vast majority of buyers, where they're borrowing from a bank, the bank simply will not hand the money over. And this is a timing and procedural problem until they have had something back from their advocate, their counsel, say after contract court, saying your customer has bought the property, they completed, your customer has given you a bond securing the loan advance you're making to them.
Yeah, I think it was that clear, that you
That-
agreed
and that's-
how you didn't have the cash.
Yeah, that's because the banks are the problem. And funnily enough, the banks are creating now a bigger problem because they don't like us writing checks. It now takes 6 days to clear a check.
Yeah.
And they're ratcheting that up to force us into making electronic payments. But we need to be able to say to them, well, fine, but you've got to, if you're funding something and you're the liquidity in the system, you've got to give us the money. Oh, we can't do that till we've got security.
Yeah.
You can't have it both ways.
That's very different from how you say.
So have they, what have they done in England then?
I don't think but you would have there's a priority thing to the banking secure.
Yeah.
Yeah, well, that,
yes, you're right. Yes,
that's
so
in
you
fact,
bank can be sure
That's
that
right.
it has priority releases.
Yes. That's right.
yeah. So that is exactly what I'm proposing on Wednesday.
Yeah.
The 1987 law contains the power for the Royal Court to make an order. So we don't have to get an ordinance, we don't have to get an ordering council, it's just an order of the Royal Court, in which we establish a register of cautions in the grave. And effectively, we protect our registration.
Yeah.
And if I can get that done, I think we can then turn to the banks and say, there we are. We have now got a system of securing registration priority.
Because that's where the difference is that that period. You don't do priority search. It can be no other person.
Yeah, it's open. That's right.
Correct.
It's open for, I can't remember, is it 14 days or so? I can't remember.
28. You can have it
28
for
it is,
28,
28. Yeah, that's right. And that, because I must confess, when I read these, I was a little shocked that, like you, I think, that you didn't have a priority period, so somebody could sneak in.
Yes. Yeah.
And I thought, God, that's dangerous. Well, potentially it's dangerous. I mean, I don't know in practice how dangerous it is, but like you, I was a bit shocked.
We tried to introduce it many years ago, the reason it didn't proceed is there were vociferous representations made by the litigation bullies of the Guernsey Bar that it would interfere with their ability to run into the Greffe at any time and slam in an act of court that their client had obtained. Now that in fact has been fixed, because you used to be able to get permission to register an act of court simply by popping up like a gopher in ordinary court. You got your judgment, and you then popped up and said, "What place you say?" And the court would say, "Granted." And you then got the Greffe to quickly type it out, and you slammed it in the drawer, and you were registered, even though you hadn't got. Sorry, not judgment.
No, it's when you
claim. You put up the plea list.
Yeah.
Horrific. So that's gone. You now have to get the leave of the court, and you've got to pass a pretty stiff threshold to get something like that in. But theoretically, you can still have a judgment lurking out there that someone had. They could go and register. So the cautions register was to do that. But as I say, the particular advocate who headed that, he is still in private practice. He also happens to be a States member. That'll give you a big clue.
I would guess that's what he said.
These things are,
Before he said States member, I thought.
Hopefully he's going to either shut up or couldn't care less, because he's made so much money. It's no longer a problem for him.
That was good, because when we were talking about that question about the registration and that point about getting it registered when the proceedings were issued, I was saying I've never seen that in practice, which is probably why you're saying it doesn't happen so much anymore because of that threshold test that's much more challenging than.
Absolutely,
than
but in charge covenants, that's why they're so unique. Wow, that is incredible. Anyway, so defendant lodges receipts. Next clause, the warranty of title and general guarantees. So you get a covenant from the vendor against rents and encumbrances, except chef-rents and manorial dues. Hello, what's missing?
Ooh.
The bit you really want to see.
Given clause 4.
Yeah, given clause 4, particularly.
Particularly, sorry. I didn't mean you only put this in. Yeah.
So there's no actual warranty or indemnity against defects in the title.
Despite the fact it's a guarantee of title clause.
It's a guarantee of title clause.
Yeah.
At the moment, you've merely got indemnity against rents and encumbrances. And even then, it doesn't cover chef-rents and manorial dues.
Can I just ask, what's a chef-rent?
Chef-rent. It was simply another form of feudal taxation.
Okay.
I've
not come across it.
Chef-rent was only payable to the crown. So it would only be paid.
Well, in English crown?
Fief le roi, yeah.
Oh, okay.
A lot of Guernsey property is on Fief le roi, as is this one.
Yes.
St. Peterborough, Fief le roi.
Yes.
What is that? The feast of the king.
Correct.
Yeah.
And it's the private fief of the king.
Strictly
speaking.
Because of the history of the island.
It's because of our constitutional history.
Yeah.
In particular, I think you go and have a chat with Darrell Ozier if you really want to get to the bottom of it. well, you could have talked to, I've got my name, Linfesty, Kate, Kate's father, who was an expert on the subject. I think it was the bulk of the fiefs ended up in the private hands of the crown after Henry V's dissolution of the monasteries and severance from the Roman Catholic Church. So although Guernsey, being unique, carried on being associated with Coutances, and we carried on like that for a couple of centuries before we became aligned with Winchester. And, of course, and that sounded a bit badly. But at that point, a lot of the fiefs in Guernsey were, of course, owned by the French monasteries. Saint-Michel du Val was the biggest one. Fief Saint-Michel. But even Fief Le Comte, I think, was another one.
Do they exist now?
Yeah. Oh, the fiefs exist. Yeah. Nearly all their rights have been stripped and commuted, and the only thing you get as the seigneur or dame of a fief now is if you are a seigneur or dame who owes homage to Her Majesty or the Crown. Firstly, I don't know whether this is a privilege or a burden. Like an advocate, you are compelled to attend chief pleas and to pay homage. So when your fief name is called, or when your name is called Seigneur de Fief Sainte-Hélène or whatever it is.
Who are these people in Guernsey now?
They're just ordinary private people.
They're still in the fief.
Yeah. And fief, not fief.
Yeah.
And they have to, pop up like a gopher, and they go to the front and they bow to the royal court, paying homage to the power of the crown. And you get an invitation to the chief pleas dinner. Wow. When you pass your bar exam, you are called to the bar. You will be cordially invited to the chief pleas dinner, because all aspirants who have just passed are given first call.
One time.
Offer.
Yeah.
You going, Heidi?
It's bad form not to go. It's one of those. It's not. It's a bit like dining in your inn. I don't know if any of you.
God, no, yeah.
Yeah, it's a bit like dining in your inn. Actually, it's not quite that good.
Oh, really?
Yeah, it's worse.
Oh, God, I don't believe it. Oh,
The only thing is, I said, wow, I used to love going to my inn for dinner.
Really?
Yeah. Great.
What gym were you going?
It's like
Place.
Me, no, I'm Middle Temple.
Me too, yes, I'm holding on.
But you'd meet all these other fellow students, and you'd get a bit pissed, and whoops. And then you'd go off into the night, and it was fun.
The food was rubbish, though.
Oh no, Middle Temple was good. No,
What?
seriously.
I mean, I was there a lot. It was the 80s.
Oh,
Actually,
yeah.
beginning of the 80s. Oh, did you? Oh, that's nice. So it was a long time ago. Sorry, because I think I'm the oldest here. Well, anyway.
So yes. How do we get onto that?
Yes. We were looking at. I said, "What's a Sheffield?"
Sheffield,
Yeah. Sorry.
Manorial dues are paid
Yeah.
in all. Yeah. So you have the large.
That's the same as medieval England.
Yeah.
Yes, I thought that was
the
the same,
Caroltane.
Yeah.
I can't think of the names now, but yeah, they are tiny payments. I remember the days, because I'm old enough, when the Crown still used to collect all these things. There was a lovely old man called, he was John, I can't remember his surname, and he sat in this little office at the side of the Greffe. And he had these wonderful pre-printed pads in which he had beautiful cursive Italianate script, and he'd write out that Mr. and Mrs. Vidamore of this house, their annual chef rent was 37.5 and he'd send them a bill for it. But it got to the point where the stamp he was putting on the envelope was getting close to the value.
Yeah.
So they are still owed. They've never given them up, but they don't collect them because they're uneconomic. And people still buy Fiefs. Advocate Mark Dunster, as his wedding present for his wife last year, bought her a Fief. She is now the Dame of Fief. Was it Canada?
Doesn't surprise me.
Oh God, that's like in England where you buy the title. Oh,
Yeah, it's basically a title.
It's a title. I shouldn't say this. Maybe I'm upsetting you, but I can't see the point of that. I really
Neither
can't.
can I.
Oh, that's all.
Yeah, don't
I
worry.
really don't see the point of just buying a
Yeah.
title. For why?
Yeah.
Sorry,
Yeah.
it just seems
Yeah.
pointless. I understand land.
Yeah.
What's
No,
the
they
point?
can't
I
issue
mean,
passports. Anyway, so there we are. So that comes as defective, no warranty against defects in title. The next clause deals with possession. It would be
I'd like a date there, I must confess.
exactly.
Yeah, you know, I'm sort of.
It's a little ambiguous. The purchase runs into immediate possession. Okay.
What?
Does that mean today?
Yeah.
Or tomorrow? Or normally one would draft it on the basis of the purchaser shall enter into possession of the premises with effect from, and then you say the date. And usually it's this day. It's immediate. Then the final clause, what we call the attestation clause, says everyone appear before the Lieutenant Bailiff and Jurors of Royal Court. Perfect. On the day near first by Britain, that's fine. The vendor will buy his guardian, Patricia Tourtel. So that's interesting.
Yeah, she pops up right at the end.
Yeah. However, that's not wrong. That's perfectly fine.
Would you not put that in anywhere before? Because I must confess, I probably wouldn't have let you just pop up there, but I could.
It's not wrong. It's not great drafting.
Oh.
Now, that is a classic example of why you'd have a little recital
Yes, that's right.
explaining the vendor was under guard.
Yes.
Also, what it doesn't tell you, of course, is what is this guardianship? Is it
Yes.
Curatel or is it Tutel? In fact, is Ronald a minor?
Yeah.
Or is he simply, poor chap, lost his mind? You don't know. So again, poor drafting doesn't tell you what is going on. But in any event, you'd want an administrator. Sorry? Correct. Any minor can own property. In fact, you can buy property for your minor children without any formality being required.
But I thought you had to have a tutor. No, you don't have to have a tutor.
Because you acquire that by operation of law. If you are the person,
Oh, I see.
if you're the person, now these days it's all covered by the children law.
Yeah.
So if you are the person who has parental responsibility for a minor child.
Yes.
Now in Guernsey, just to explain, historically, only the father of a legitimate child had the guardianship. That is, strictly speaking, still the case in some. They're looking at changing that law by way of parental responsibility. So I have certainly concluded a conveyance for, I think the child must have been about 2 years old. But Dad decided he wanted to buy a property to benefit his child, and ultimately he hoped to fund his university education. So he bought this house because he had some spare cash, put it in the name of the child. We did the conveyance, and
the only part of the purchase
is the child, 2-year-old child, who was there with his dad in his arms, but because Dad had full tutel under the customary law of Guernsey, it was the father who consented to the purchase. You don't need any act of court, because as far as Guernsey was concerned, what better thing could you do for your children than give them property?
But you do need a tutel, don't you? You don't need to, so if property, so,
If you need no order to buy. Dealing with it
yes, I think, yes.
is a
that's right.
completely different thing.
Then you need the tutor, yes, sorry, I think, yes, yes.
Well, you
yes.
can rent it without any order because that's in persona.
Yes.
See that
Yes.
distinction
Yeah,
again?
yeah, yeah, yeah.
Anything you do that is either a claim or a dealing with a droit immobilier, so that's ownership,
That's when you need the
granting of a right of way, you would need an act of court giving you permission to do the specific thing you want to do.
So if the miner buys a house with a field, a garden.
Yeah.
Give the garden to somebody.
Well, let's say 10 years later,
Yeah.
the neighbour comes along and says, "I'd like to buy a bit of your garden.
Yes.
I'm prepared to pay, 4 times the market value." Then, of course, the parents are going to say, "Well, this is fantastic because we can put it in
Yeah.
little Johnny's trust fund or into his, education fund, whatever. We still got the house. We're still getting the rent from the tenant. The garden's a pain in the neck because it's so big and we have to maintain it. Let's do this. We need the Royal Court's permission." However, the Royal Court, if presented with valuation evidence that this is way over the real value, they are not going to say no.
An application made by the guardian.
Yes.
So you need to appoint
Which court would you go to? Juror.
That would be ordinary court. Yeah.
But on a Friday.
I think these days, don't you do it? No, you still do it on Fridays, don't you? It's got to be jurors. Yeah.
The juror.
Yeah. Oh, jurors is Tuesdays. Yeah. Yeah.
So would you, as the parent, are you automatically regarded as tutel, or do you have to appoint yourself to tutel and then apply?
No, if you have parental responsibility
Responsibility
as a
and
matter of law, you don't need an act appointing you.
You just are.
Yeah.
Now, is that following the children?
Now,
Children's
following the
law.
children's law,
Yeah.
Would it be mother and
it would
father?
probably
Yes,
certainly
it
be
is.
mother and father.
Yeah, I think it is in the notes, I think. It's in the succession bit. Yeah, sorry, I don't know why it's, well, I don't know. That's where it's been put.
Historically, it always appeared in there, but I'm not sure why.
No, because
think-
it actually crosses into
I think
other
because it
ones.
crosses over and
I put it in succession, but I don't know why.
Yeah, quite right. Yeah, but
But I think you do need to know it, let's put it that way. But
I think it's got any way to do it.
yeah, it is, isn't it? Yeah.
and in this particular case, and confirmed ratified this against what's fine. Except that, what are we? 2012. Okay, this is a bit old.
Yeah.
So there's now something else you need to say.
Or is it-
Correct.
Yeah.
You now have to, under the new document duty law, make a declaration as to, relevant to the circumstances. Here, because we appear to have a transaction at arm's length, at market value, it would be a very simple
But
declaration.
you have to put that in, don't you?
You have to
Yeah.
make the declaration
Yeah,
of
that's what you
yeah.
did.
And you could have some words in there, very simple. The parties declared in accordance with Section 5 of the Document Duty Law 2017 that A, this transaction is arm's length, and B, the consideration stated above is the full consideration for this transaction, full stop. That's it.
There's quite a lot in that, isn't there? Because there's more to come as well.
Yeah. Yeah, that's just part one of one
That's just
question.
No,
No, okay,
I actually thought it was
we-
quite a nice question.
We've diverged slightly because
Yeah.
it gave me the opportunity to tell you a few things
In context.
in
Yeah.
context. Yeah. So part two of the same question. Yeah, this is all to do with. This is much more to do with, of course, this horrific manual. And
No, it is actually all in there.
it's in there.
Yeah. I don't know whether you want to add it. It's all in. I can't remember which bit it's in now, but it is all in there.
It's in there. But,
In summary,
right, in
Oh.
summary,
Oh, Heidi. I can't remember where it is in there. It is.
is the whole point of
Yeah.
it is that under the 2005 planning, a breach of planning law or building regulation,
Yeah.
or more specifically planning law. Look, building regulation is slightly different, but a breach of the law doesn't remain with just the person who committed the breach. It follows the property. That, of course, is a major problem because, in effect, it made a person criminally liable for something they hadn't done.
Would you always take action immunity certificate from them?
If it is a straightforward purchase like this, you would always say to the buyer, I strongly recommend you have an immunity certificate,
Okay.
but it is entirely your choice. You don't have to do it.
Okay.
is it looking at the circumstances? If this is the property, you go and see it and there's nothing around.
Well, exactly. So it's up to the purchaser.
Yeah, that's what you're saying.
Yeah.
Yeah.
Can I just ask one other thing?
Yeah.
Does it cover breaches of building regs? Oh, I don't think they're called building regs. They're called building.
Yeah.
What are they called?
No, they are building regs.
Oh, they are building regs.
It does up to a point, but there's a little twist in the
Oh.
tail, and that is that whilst it will give you immunity in the sense that you won't be served with a compliance notice. The way they, blasted planners, they get around it, is that the moment you then approach them for a minor building application that engages with the building regulations, one of the terms and conditions of your permit is that you correct the problem.
Yeah.
So you end up having to fix it anyway.
Yeah.
But they couldn't serve a compliance notice on you to make you fix it. But then you can't do the little extension you want to build without fixing the original problem. Cunning like that. So yes, it does protect you, but
when you talk about the risks,
the risk is you are served with a compliance order compelling whatever the breach of planning law undertaken was, that you now correct it.
Most people get them when they're buying properties.
I would say
that
that
planning regs is slightly different. So the breach of the planning law, you get this notice and then you go and ask the permission to do an extension, you're okay.
Yeah, the planning bit is fine because they have such extensive written policies they have to comply with. Building regulations, because they're purely technical.
Yeah, they're what the builders must do. Really.
It's what the builders. So if you've got a staircase which doesn't comply with building.
Yeah, they're at certain angles. They have to be at certain angles. If that, you can't have them going like that.
Yeah, you can't have them like that. You see.
And then roof pitch. Sorry, so
exactly.
as an architect, this is one of so roof pitch is all this sort of stuff.
Yeah. So there's a little twist with building regulations that you discover that becomes of your building license, because you get a separate planning permission and license. So the planning permission says, yes, this work is authorised under the planning policies if you comply with this, this, and this. And then you have to completely separately apply for the technical regulations.
Make sure how you build it.
Yes, that's right.
Exactly.
You've got
So-
to build it as you're told to build it.
Yeah.
And comply. Yeah.
Yeah. Oh no.
No, they don't do that. It's any sort of changes. Yes, that's
Correct.
it. That's right. Yes, yeah.
I mean, usually
Part two, though, doesn't seem to be
I mean, I don't know.
It's really.
Oh, it's all. It's, to be honest, I just no. There's loads of stuff in the, no. There's loads of stuff in the back. Just sort of load it up. What was I going to ask? Oh, I assume. Sorry, this is just me going off on one because I don't think this is massively relevant. But I presume that you've got listed buildings. So
we have what's called
protected buildings. That's what you do. And I presume with regard to those, the planning. I don't know. Would it be? I suppose the planning and building regs actually are slightly different at times. Does that make sense?
Only in the context that in granting any permission, the planners have to take account of any report written.
Yeah.
It's all frankly, it's all the same department.
Yeah.
So what happens is you just get enhanced terms and conditions applied to your planning permit. The building regulations, they will then interpret them in a way that is sympathetic.
That's right. So you'd have to use certain materials.
Correct.
Yes.
But as I say, the immunity bit, in a way, it's down to the client, whether they get one. I would always advise they do. In fact, it's not £50 anymore, it's 70 because it's gone up. There is a circumstance in which they have no choice in the matter, and that is if they're borrowing money from a bank. The bank will simply say, you don't get one penny if you haven't got an immunity certificate.
Most people are getting them anyway.
So most people end up being forced to get them whether they like it or not.
But I'm personal property.
Yeah, I agree with you. It gives you some peace of mind.
Yeah.
I agree.
Yeah, it's always like planning.
In a way, yeah.
It is. It's just But there is. I mean, you said there's not a lot to say. There's loads of stuff, and I'm just going to just load it up current fashion.
In a way, yeah.
Yeah.
I mean, there are a number of circumstances where you won't get an immunity certificate, and that potentially could form the basis, perhaps, of a question.
Oh.
Well, if you're planning on if you're potentially, you could.
Yeah, I'm with you.
Acquire property from a person.
One of the exclusions is that you have to make a declaration that you have not been an owner, occupier, or in effect have any connection with the property in the previous 4 years. So if you're playing around with flipping the property from corporate vehicle into your personal name and the corporate vehicle committed planning breaches, you can't use the transfer as a way of evading liability. That's a classic one that they've shut the door on that one. And interestingly enough, of course, the taking of a bond or a charge against a person securing their property is, because it does not involve the transfer of an interest in real property, means that where a bank is loaning to an existing homeowner, the bank can't get an immunity certificate as part of the loan process.
What basically you're applying for a loan to build the extension.
Yeah, exactly. So in those circumstances, the banks have just had to swallow it and accept that, well, they're not going to get one. So they have to resort to the old-fashioned technique of saying to the borrower, perhaps, you will employ a professionally qualified person to write a short report to us on your drawings and your planning permission, so that we've got some protection that what you're building is not going to be subject to a compliance order, and or have some kind of sign-off certificate.
So
however the bank wants to do it.
Why can't they apply for immunity certificate on a second?
Because that's what the law says. That's just the way they wrote the law.
So that owner would make.
Yeah. Yeah. Do you want to deal with part 3?
I don't know. I'm in your hands. I've told you that. We've got.
We need to crack on really with bonds, don't we?
We did some stuff. We need to. I think we need to.
We'll have a quick look at.
Yeah, we need to look at. We did do bonds yesterday, and it was priority we did on bonds. Now I don't know whether I didn't see it. I didn't see.
I mean, what's in the manual, I'm very happy to convey.
Some of it needs
This- this-
rejigging a bit.
Yeah, I must admit,
It doesn't-
when I read it again, I think, no, we've looked into ourselves here. But
Yeah, and that's
Yeah.
the problem. I too am sort of.
Yeah.
But I think they need to be in a
Yeah.
different order.
But
They're not quite as
I'm
logical.
very happy what's in here
It's
is
correct.
good, it's comprehensive, it's correct.
It just needs I know it needs to be.
Um,
So we did do bonds yesterday.
We're
It was-
just going to quickly read
Yeah, if you want to.
Yeah,
I'm very
That's
much
what I
in
was
your
asking.
hands.
Right,
Yeah.
okay. Because this
hold on.
is all about,
Oh, yes, lots of
searches.
searches.
now we've had a quick chat about searches already. The reason the question says you're being asked to sign unconditional conditions of sale
Mm.
prior to completion is that, in other words, Vincent and Violet are going to commit themselves to buying the property, and they're not reserving the right to withdraw on the basis that they've discovered some defect in the title. That's what it's really getting at.
Is that the unconditional condition of sale? That's
Yeah.
the point.
Would people normally enter into unconditional sale?
I would say that in 90% of all transactions in Guernsey, if the parties sign conditions of sale the day of court, they're lucky. They're often signed afterwards. The whole system's a mess. We are, again, Muggins here stupidly put his hand up and said he'd redraft the bar conditions. It is
Well, the what? Conditions of
the standard form,
the standard one.
because they're horribly outdated.
Yeah.
They are just not any longer fit for purpose. They're over 20 years old. It is it's a Sisyphean task. Every time I push that boulder up the hill, it rolls back down again. And in fact, payments, I got to that point in the draft, and I thought, my God, until we resolve this, it's almost impossible to redraft this, because this is so fundamental at getting this right, because it just removes this huge problem area that otherwise you have to contractually provide for.
So in most cases, people will buy property on the condition of sale.
Almost instantaneously with completing a contract.
Yeah.
Because they can pull out. So that's why it's
Correct.
trying to recommend this condition of sale, but it may make no sense. Still,
Well, you've got to remember, again, the conditions of sale in Guernsey, very quick recap, I would call it a forfeit contract. That is actually what it is. It is, if I don't perform my promises, I forfeit. The forfeit is 10% of the sale price, as laid down in that Trinidadian case, Privy Council case. Workers' Bank and Dojak, I think it was. But because we don't have remedy of specific performance in Guernsey, that you have committed to buy and the vendor's committed to sell, neither of you can be compelled. If you don't mind losing a big chunk of money, fair enough. That's damages. That's what they are. So
that's the point saying that they do on the same thing, because you don't give your deposit over until you're sure you want to complete.
correct.
Yeah.
Because you don't want to risk your
You
money.
don't want to risk the money, yeah.
Plus the fact so many people discover they haven't got the deposit. They then go to the bank and the bank says, no, we don't loan deposits.
Yeah.
And they suddenly discover they couldn't pay one anyway. So you end up with conditions of sale with lots of special conditions where you waive the deposit.
That's
that
it,
you
yeah. Conditions of sale, that's what I say, conditions of sale and special conditions.
Yeah, with special conditions where you waive the need to pay the deposit, but the damages are still 10%.
Yeah.
The vendor, of course, has to weigh up the fact that he's entering into a contract with an impecunious buyer who clearly hasn't got any money. So what's the point of having damages if they haven't got any money? He might as well reserve his options, and just in case somebody knocks on his door 48 hours before completion and said, I'll give you more than the asking price,
Yeah.
you know,
This is where it's quite different.
it's never
When you say
happened, but
is
it
you
might
don't
have.
get exchange of exchange of title, satisfied stuff.
Yeah.
Title,
Yeah.
pay the deposit, so
Yeah.
committed,
Yeah.
But
and then
with specific performance, you know completion is going to occur.
okay,
Yeah.
That imperative is not here in good.
No, but the way they get around is the damages.
Correct. Yeah. So
Yeah.
which means that, oh heck, I'm not going to risk this money until I'm really sure.
Yeah.
So
Okay.
you're being asked here, okay, if they're signing on that basis, what searches have to be carried out? So this is dealing with a huge range of issues that crop up throughout the whole of property, which is essentially, I'm trying to summarise them on the hoof. It's proof of the vendor's claim to possession. So what you're doing with searches is you're testing the vendor's claim. Now, in conventional transactions, you've probably been handed, or you have had made available, a conveyance to the person who holds themselves out as the vendor. It's exactly the same parties, the same people. They bought it 18 years ago. Fine. In that conveyance, if it was reasonably well drafted, it'll say where they got it, who they got it from. It'll say the person from whom they bought it, where they got it from. So straight away, you potentially have got evidence which you can verify within 20 minutes of title going back anything up to 40, 50 years. You don't have to verify it that far back, but it's lovely when you can, because it tells you exactly what's going on. And it's that constant process of saying, this all rings true, it's verified, it fits all the facts every time. So you're searching against the vendor since the date they acquired the property. You want to make sure, A, they haven't sold any of it. B, interestingly enough, they haven't bought another bit, but they forgot to hand you over the document that evidenced that, and your clients are expecting to buy it also. And C, have they done anything or been a party to anything that has affected the conveyance or the title as they originally acquired it? Have they given rights to someone? Has someone given rights to them? And finally, you do a search against the vendor from the date they acquired it. Have they given anyone a charge against them which would secure the property? Now, the other search, which the question is alluding to, is a site visit.
Yeah.
And you would absolutely, and it's really key, expect a site visit to be carried out. And fortunately, in this day and age, we are far better equipped than we ever were with digital cameras. And so when you send someone out, if you don't do it yourself, and you go and see they go and see the property, and they come back armed with, anything up to 50 photographs. And as you're sitting there with the original conveyance or other title documents, and then they show you the photograph and they say, right, well, title refers to this line of boundary stones. This is actually what's there, and you're looking at it, and there's nothing, which is typical because people, especially with the old-fashioned boundary stones, they're beautiful granite pillars.
Who are they?
Oh yeah, just granite pillars. So what happens is people take one look and go, oh, that looked lovely in the garden, pluck, out comes the boundary stone. 20 years later, where's your boundary? Oh, I don't know, there was a stone. Oh no, I moved the stone, it's over there now. Oh, right, okay. Happens all the time. Or, it refers to, and I hate it when I find this. It refers to the boundary, we own up to the shrub hedge between our garden and next door's garden. shrub hedge is the stupidest thing on which to base a boundary. They're
Because
living.
it,
Well, not only do they move, they die.
yes.
And then they're gone. And like the boundary stone, you're looking at a nice expanse of grass.
Yeah.
Oh, I mow up to there and the neighbour mows up to there. Well, was that where the hedge was? I think so. It was around there somewhere. Or alternatively, there's a reference to a lovely granite wall that divided the rear gardens. And you go there and there's a wooden fence. And you say to the owner, who's seems a bit sharp, what happened to the granite wall? Well, you make it inquire through his house, but what happened to the granite wall? Oh, well, it had some quite nice granite in it, so he demolished it, sold the granite, and put a fence up. Was the fence in the same place? And we think so. But that's the kind of search you're doing to test the vendor's claims to what he owns. In addition, because that's the sort of pure title stuff. In addition, you would obviously carry out, and these days it's all online, a rapid search at the cadastre. Partly because it gives you the necessary information to apportion rates and taxes at a later date, but also because it's a fast shorthand way of discovering who the owners of adjoining properties are. And to back up your searches against the vendor, you check their title, just in case there was a mistake in the title of the property you're looking at, but fail to mention, oh, but there was an agreement. And next door's electricity cable is buried underneath the front garden. So don't go trying to dig some foundations for your new double garage because you're going to electrocute yourself. Again, it's this double and triple checking.
Because I guess if there's been some sort of right given to them that has been missed off the conveyance later on, that you should pick it up in there.
And you pick it up
It's
there.
not been
Exactly. Yeah. What other searches could you count? I mean,
Would you do an intestacy search? If that's what makes sense. You know, sort of checking.
well,
Would you not?
these
No,
days,
checking births, marriage. I think that's
yeah,
what
these days you don't do that because you go for the administration order. But as with the partage I'm doing for these two brothers, of course, I've got somebody, poor chap, he's trawling through sales and purchases from 1834 onwards. And everyone seems to have the same name. They're all Jean or Pierre. You know, it's Jean, son of Jean, which is pretty confusing. You know, the daughter is called Rachel. Oh, so was her mother. They weren't very imaginative. And yes, we're also checking births and deaths because we're trying to find, well, when did she die? Okay, so what happened to her share in the property? So sometimes you do have to do that family tree kind of search.
For the administration, it was would she have had any right to?
Let's looking for. Let's looking for.
Sorry, not John, but when you find.
Oh, Ronald. Ronald's father. Okay. Oh, he yeah.
Yeah, but I thought we were.
Yes.
Yes, she would.
Yeah,
Yes,
under the 54
Yes.
law, she would have had this enjoyment that none of us ever knew what it was. Well, there was some weird calculation where up to one-half of the property not exceeding an annual rental value of £200.
But there was 100.
It was-
but you take the full
yeah.
100. Oh, I can't. Yeah.
It was nonsense.
Because, you know, if he had inherited property, might it still be encumbered with her right to join?
Let's think. What the administration order does, yes, it would kill it off, because if you look at the law, and I'm going from memory, I'm pretty certain the relevant section declares that the administrator is vested with all of the title held by the deceased at the moment prior to his death. Now, prior to his death, his spouse
Hasn't got any.
hadn't got any.
No, it's not you. Whatever.
There's no use fee, there's no enjoyment, because it only arose after death. So that's actually a very interesting point. I've not encountered it in practice yet. But yeah, it would have effectively destroyed her rights under the 54 law. Correct, because you can put that all to one side. So yes, we've dealt with all the ground canal searches. You know, you could have highly specialised searches that don't crop up that often. Very rarely, a client may want a planning search. That is so rare. I have not carried one out since the new law came into force. Yeah, because the immunity certificate does the job.
Yeah.
Yeah. And they're expensive. They take a long time. The whole thing is a bit strange, because you sit in a room with a planning officer. The planning officer has the file, and it's closed, and he says, "What would you like to know?"
Well, you don't know what you want to know. Really.
Correct.
That's the
Because
problem.
but he
You
won't
tell me.
No, he won't show you the file because it's not public record. So you have to go through a bizarre interrogation process, and he starts looking things up. And he might or he might not turn it around and show you, if you're lucky. And you have to make handwritten notes. It's awful. Anyway, and no, they refuse to make them public. That's why we had this ridiculous immunity certificate regime going on. Yeah. And what other? I suppose if you were buying an apartment in a building which is higher than 2 stories. Have I got that right? 2 stories? Yeah, oh, yeah. So ground floor, first floor.
Yeah.
So if you've got second floor, you would probably fire off an inquiry at the fire safety officer to check that the premises are have been inspected under the fire safety law, because they are controlled premises for the purposes of that law. The Fire Safety Law 1989, as amended, as usual.
Yeah,
Yeah.
that makes sense.
Admittedly, that crops up invariably in commercial transactions, because all places of work are automatically controlled premises. This is controlled premises.
Yeah.
It does not apply to private dwelling houses, and it does not apply to any apartment building of 2 stories or less.
What 2 stories are you counting?
So ground floor, first floor.
First floor.
So if you've got the ground floor flat and a first floor flat, it doesn't have to be controlled premises. If you've got a second floor, controlled premises.
But a townhouse.
If it's in one ownership, no.
No.
No, private residences never fall into it, no matter how tall they are.
Not even if they're HMOs.
Oh, well, a HMO.
You've got you should have got other laws.
No, there's another test under the law that if it provides sleeping accommodation to more than, and I can't remember how many persons, 6 persons. So a HMO falls into the law for that reason.
Yeah, okay, that makes sense. Yeah.
Okay.
Okay, 10-minute break. Oh, see you. Has she got any biscuits out today? Which one are you looking at? I don't mind which one. 20 September. It's all right. September 2012. I looked at this. No, that's not. There was one I read which was the print was so tiny. No, this is all right.
Yeah.
No.
Yeah, this is a print. I think he mentioned to Simon a couple of years ago. Simon, why don't you put in a handwritten? And he said, I have thought about it. He said, but when I discussed it with Richard McMahon, we thought that was perhaps a little too much.
I agree. You've instructed.
I said, oh no.
Order property, good parking, bloody, bloody, blah, bloody, bloody, blah. Hold on. Andrea, no. You're instructed Thomas James, bloody, bloody, blah. The agreement warranties and honest finance. Hold on, James, so this one is Arthur.
That's what I'm looking at.
That's what she's the one, isn't it? That's okay. That's fine. That's fine.
Yeah.
Let's go get a cup of tea. Oh, I'm gutted not. that weekend. Oh dear.
So where do you fly here from?
From Birmingham. But I mean, we're in the country. I don't like cities. I'm a country girl, so we live in the country.
You have to do that. What's it?
Yeah, we do the
Direct to. You can get direct to Birmingham.
Nah, tonight I will be going by Jersey. That's right. But coming over, I'm into
Going
Jersey
direct.
straight. That's right. Yeah,
Yeah, it's that way around.
So
Yeah.
it depends on what time flight you can. They sort of vary.
Yeah.
Why do you fly into Birmingham?
No,
No, that's not too drunk.
I used to.
Did you?
Yeah, my second friend.
But how many people love?
Two.
Oh, I know, sorry,
No,
Is she from?
she used to live in a tiny village just down the road from Bangor.
Oh, all right. Oh, that's quite nice.
Lovely area, lovely
Yes,
part of the world.
it's not.
But the nearest airport is Birmingham.
That's right. Because it's a choice. There's Bristol, but the airport's southern Bristol, so we've got to get. You know, there's Cardiff, but Cardiff's got limited flights. I don't know. It's not that brilliant. Yeah. But, you know, if you want to go to, I don't know, English or something like that, it's great, but it's not great to Jersey, Guernsey. So Birmingham is probably the best, and it takes best about an hour. I suppose, to a short flight.
Okay.
Righty ho. No, I should have just quick peek at this one. Right. Oh, God, I can't read. Oh, wait a minute. No, I'll read it there. Forget that. Sorry.
17.
Oh, we are. Yes.
We're going to have a very quick look at a French conveyance.
I say 17.
Sorry, you have to do it at some point.
Yeah, I just think it's good for your souls. No. Yeah, no, you do have to learn French conveyance. Sorry. You do. Oh yeah, September 2012.
September 24th paper.
Well, it's right.
Yeah, it's the appendix at the back.
Yeah.
Number 338.
That's the one.
That's one. Yeah. What does that say there?
17.
How?
Oh, that's beautiful cursive script.
Is that a? Does it really say that?
That's 17.
I thought it said 1A stroke D.
No, that says 17.
Okay.
That's how.
Okay.
Oh God,
No, doesn't even look like French writing.
that would have been Jack.
Date.
1964. The Graf Stronger Club would have been Jack.
Okay.
Yeah, beautiful writing. You see his registers; they're made up.
Like that.
Wonderful script.
Still don't understand. Sorry.
Right. Okay. So
Anyway,
we're
don't
looking at this. Hopefully, you've got it in front of you.
You've got it. Oh, is that? Oh, hold on. I don't think I have that. Hold on. I've got.
Okay. So I'm not going to translate the whole thing for you because we're running towards the end of this session. So the French style conveyance, this is obviously a relatively late one, 1964, only 5 years before it changed. So it's typed, which is nice because you read it a lot easier, as opposed to handwritten, which sometimes can be challenging. Okay.
The paper, there is another one in the paper.
Oh, there's a different paper.
So it's September 2012. It's April 1964.
No. No, that was really you all got it. Perfect. That's me. No, yeah, sorry. Sorry.
Now, these did follow, strangely enough, a much more conventional layout, which didn't really vary at all between all advocates. Having said that, when I say all advocates, you've got to remember when I started work on a temporary contract at Carey, Longley and Co, as it was in those days.
Only 5 years ago.
Yeah, the total number of advocates at the Guernsey bar, I think, was 16. That was the entire bar.
Really?
We all used to fit quite cosily into the Prince of Wales every Friday night, including the Crown officers and sometimes the bailiffs. They were much more conventional in their layout. They always started with the date, always written at the top. And instead of being at the attestation force saying everyone appeared before the court, it starts at the beginning. So it's literally back to front in that sense. So on that date, before all the bailiff and judge, the court, etc., appeared, and then it names in the same order as we have in an English style layout contract, the vendor. Here it's a chap called Arthur Bernard Bridgewater. Notice we have the convention expressed in French in the same way, fils d'Arthur, son of Arthur. It then briefly recites his address and then says in a very specific and highly regulated French way, who of his own free will and accord acknowledges having fiefé et baillé. The word conveyed never crossed our ancestors' lips. That's not what they thought of. What he was transferring here was his fiefé, his ownership. Baillé, sold. Bayreuth, from himself and his heirs. That's still in the conveyance, remember. So his warranty is from himself and his heirs. Enfin et perpétué, or perpétuité d'héritage. Absolutely forever for an estate of inheritance. That's our equivalent of a fee simple. It's the best you can get, like Gillette. And he's doing that as a contract with William Alfred Sidney King, fils de William. Should be fils de Guillaume, but there you go.
Yes, it should really.
Anyway, that gives his address, and Emily Mabel Cully, Safan. Now, just a little twist here, just to explain why that is. That's his wife, but she's not Emily Mabel King, née Cully. She's Emily Mabel Cully. Now, to our ancestors, the idea that a woman gave up her family name, rubbish. She was born Cully. That's her family name. It's important. She might be the wife of William King, but she was always Emily Cully. This idea of describing women as née, totally English idea. Anyway, they are present and they accept pour eux le survivant des deux et les joies du tel survivant à jamais. Accepting for themselves the survivor of the two of them and the heirs of such survivor forever.
So accepting for themselves and the heirs of their survivor.
And for themselves
And
the heirs of the survivor.
Sorry, for themselves and their survivors. The heirs of them.
No.
For themselves, the
survivor
survivor
of the
them,
two.
For the survivors,
Well, the
so
two of
that's
them.
what they
Yeah,
do.
sorry.
So for themselves.
Survivor.
Accepting for themselves, their heirs and their survivors.
No.
What do they all
for themselves.
For themselves.
for themselves? So that's
Le survivant des deux, the survivor of the two of them, literally, and the heirs of such survivor forever, which reinforces the point. Enfin et perpétuité d'héritage. And then it, savoir translates as to wit, To wit. It's describing a maisonette, which is a cottage. So we've got a cottage called Malgré tout. Garage, spelled exactly the same way in French as it is in English, because it's a French word actually. A jardin, garden. Tout joignant ensemble situé à la rue des Corneilles. So the whole adjoining and situate at the rue des Corneilles. My God, that's the ancestral seat of the Letitia family.
Oh, is it?
Yeah.
Oh.
On a dit paroisse du Cassel, in the parish of the Cassel, sur le fief le Comte, on fief le Comte. It then gives in brackets a little bit more information. It says, l'assiette des prémices de ce bail formant ci devant partie d'un côté appelé le Pré des Corneilles. The site of the premises of this sale, formerly forming part of a field called le Pré, the meadow of the Corneilles. All fields in, nearly all fields in Guernsey have a name. That's how we can trace them back. A gisel. Gisel means lying. And here's the big twist.
Forming part of what, sorry?
Formerly forming part of a field called, and in French it's called le Pré des Corneilles, which literally means the meadow of the Corneilles. And then it ends with that little section. You'll notice nothing is numbered, nothing's split up in the way of an English laid out conveyance. It's literally a continuous text. A gisant. Gisant means lying. Now here's the big twist in the French conveyance. We saw in the English draft that the boundaries were given by reference to the compass points, oriented to the compass points in a clockwise direction, as if you were hypothetically standing inside the property looking out. So you looked to the north and you said, on the north there's a house, on the east there's a field, on the south there's a road, whatever, however it went. Here, the property is lying. So the oddity here is it says the whole property lies to the north of. So you need to turn round. It's the opposite way. You're actually describing what in English we would be addressing as the southern boundary. So the whole parcel of land, you're saying it lies to the north of. Oh, actually, I need to look behind me. That's what I'm actually talking about. So you go to the north of, but you follow the same convention, north, east, southwest, but you're doing it back to front. Yes, I know, our ancestors had a great sense of humour.
Makes sense.
It kind of makes
It still
sense.
makes sense. If you're using the term lying to,
Yeah.
then
Yeah.
Lying to.
The north of. And it says,
So the property is lying to the north.
and it says, au nord ou environ. Now you will see that word ou environ constantly repeated every single time throughout every boundary. Au environ means or thereabouts. So it's to the north or thereabouts. Now this is the point I was making. People get awfully trapped into interminable investigation of boundaries down to, the nearest centimetre. Our ancestors would have been amazed because the description of the boundaries was a kind of generic, well, it's to the north or thereabouts. Doesn't have to be that accurate, but if you look behind you to the south, you're going to see this.
we didn't have that in English.
No.
No.
So to the north or thereabouts, a cottage called Vue des Sapins with a garage and a garden. See, once you've learned the words for garage and jardin, they keep popping up. So you only have to learn them once. Appartenant, belonging to Elizabeth Fink. Oh, what a great name.
That is a great name.
Elizabeth Fink. Here again, that's her birth name. Femme de Monsieur Henry Edward Duckmin, so she's the wife of Henry Duckmin, but she's Elizabeth Fink. Don't forget it. La défense en bois entre deux appartenant à Edith Fink. The fence, défense, en bois, in wood, between the two, belonging to the said Fink. So it's her fence. So the vendor is saying, I am happy to say, I am handing you over title up to, but not including, that fence. Then we lie to the east of, so in other words, our western boundary, we lie to the east or thereabouts, and bordering the said Rue des Corneilles, so the road. In a way, it would be interesting to have looked at a slightly earlier conveyance, because I'm afraid by this time, practitioners were doing something that has irritated me for a long time, and that is the property doesn't actually stop at the public road. It is a presumption that is raised that the property in fact owns up to the middle of the public road.
Oh, wait a minute, that's got consequences.
Why?
If the property owns up to the middle of the public road, does that mean?
That's how all property in Guernsey is ranked. The States of Guernsey do not own the public roads.
Then who's got the onus of maintaining them?
States of Guernsey, by law.
Right, okay, I'm happy with that. Sorry, what you could see where I was going with this. I was thinking, oh no.
It's an ordering council of 1904.
Right, okay.
Now, if you looked at some of the older conveyances, they are far more accurate. Because in fact, what it would have said is it would have said, à l'est ou environ de, I don't know, let's make it up. Or we could use the previous one. L'est ou environ d'une maison appelée Rue de Saint-Pin, appartenant à Dame Elizabeth Fink. It would then say, la dite Rue des Corneilles, entre deux. So it told you, right, your owner that you border is Elizabeth Fink, but the road lies between the two of you. This is an English influence again, which destroyed some of the purity of our conveyancing, in that because you have Highways Acts and different concepts of ownership in England, although often in England you can own up to the centre of the road. That can arise. Because you had Highways Acts, practitioners over here came back all shiny and new from English universities and promptly adopted English thoughts and started putting them in the conveyance. And they started just saying, oh, you're bounded by the road, as if the road was some different other thing. It's not. And just a little very recent example of the implications of that. You had the owners of the brewery, Havelock Waters, down at the bottom of the Val des Terres. Last year, they made an application to the Royal Court to incorporate a small part of the public highway into their landscaping and forecourts. In other words, it was closed to the public. Other than the ignorance that was displayed by at least one of the constables as to what the law was, which was hilarious. Of course, what most people then said was, well, why are the states giving this land back to those developers? The states are giving nothing back because it was never the States of Guernsey. It belonged to them anyway. And the States of Guernsey now don't have to maintain that bit of highway. Hey, so you, the public taxpayer, you now have to spend less money. Why are you objecting?
Well, there must be something in the legislation about it. So, as the landowner of the road.
There's no legislation, it's customary.
It's customary.
No, that, sorry, no, but
The maintenance.
the maintenance,
Yeah.
overrides it. Because I was the landlord, I was the landlord of that road.
Yeah. No. That's a completely different piece of legislation. And it's a bit of an amalgam of customary law with the ordinance, which is an extremely long one, of 1840. The 1840 ordinance, which is known as the Ordonnance relative à route, rue et chemin. and it's kind of a mashup of early building and planning regulations and regulations concerning roads that goes on for pages and pages. The application by the developer was made under that law. That law is still extant, and absolutely great chunks of it are still relevant law. It at the time dealt with maintenance of the roads, which was the obligation of the landowner. The constables could compel the landowner to come out every year and repair the bit of road in front of his property, and even prescribed the size of the stones he had to use to repair it. Wonderful.
It is, no, it is interesting.
But that explains why, as I say, in Guernsey terms, whilst you might border a public road, don't think that your ownership stops at the road. It actually continues. It's only a presumption that you go to the middle. There are circumstances where you might own the whole width. But that 1840 ordinance made it clear that nobody could interfere with or close any part of a public road without the consent of the Royal Court. We don't have public rights of way in Guernsey. They don't exist. Think of it the other way around. If you own land, someone comes onto your land, they are a trespasser. In terms of a public road, what has happened is your civil law right in the law of trespass has been suspended. You can't prevent anyone passing over the bit of your land that is public road. Only the Royal Court can make such an order. It's a different way of thinking through the issue and then coming to a solution. Well, you work out who the owners of the landowners are either side. Yeah.
That's it. Yeah. And then, you know, the bit about the top of the Volkswagen, the green grass, piece of land there.
Well, whoever owns the field next door probably owns it. Yeah.
Yeah.
Yeah, that's all part of Fort George.
But they own that.
They own that.
Yeah.
But they own that as a private. Again,
in their own right.
Yeah. Again, this is really a public law issue. You have to get out of your head that the States of Guernsey is public. It owns land in a private capacity as landowner. Yeah. Anyway, that slight digression, but just to clear up the point, which lots of people get very confused about. And then it carries on. We're doing the same thing. You lie to the south or thereabouts, Morbihan again. D'un passage, well, that's easily translated. It's a passageway. Belonging to the company, Société, called, what a great name, Flock Investments Limited, a well-known developer of the 1960s.
Are they?
Oh, yes. Yeah.
Are you being serious?
They developed a lot of land. Yep. And once again, we've got some similar words that occurred earlier on, so you should be easily able to translate this next bit.
Belonging to the property.
Correct. They don't say property, they say this sale. Yeah. And we've then got, oh, this is exciting, we've got rights. So in French, they're expressed in this way. Et auront les dipreneurs les droits du civil des deux et ayant cause. Right. And, badly translated, shall have the said purchasers. So the purchasers shall have. Interestingly, in French, they always used to give the vesting. So they were accepting the droit immobilier, the subsidiary rights, in exactly the same way they'd accepted ownership of the property. Fascinating. We now don't do that. We just talk glibly about successors in title. So they say here, they have given William and Emily for themselves the survival of the two of them, ayant cause. Now this is a funny bit of relic French. Literally and assigns. That's the French equivalent of successors in title. So
literally undersigned.
Yeah, ayant cause is translated best of all, successors in title. And then we've got the right itself. Droit de passage, de pied, et de tout véhicule. Right of way on foot, pied. And the two vehicles, and with all vehicles, y compris automobile, including automobiles. Par-dessus, over, le dit passage, the said passage, pour aller et venir, toutefois et quand, to come and go at all times. Toutefois et quand. Again and again, you're going to see these words crop up. So what we commented yesterday is that there's a relatively limited vocabulary. Once you, I'm sorry, it's something else you've got to learn, but once you've got the vocabulary, it suddenly becomes so much easier. Entre, between, la dite rue des Corneilles, between.
Yeah.
Sorry?
Where?
Toutefois et quand. It's just an expression. It means toutefois et quand, at all times. At all times, and unlimited. Yeah. Between the said rue des Corneilles et les prémices de ce bail and the premises of this sale, on paying their proportion, en payant leur proportion, that's easy to translate, des frais du maintien, of the costs, frais is cost, du maintien, maintenance, de la, and there's a, well, I said presently, it's just badly copied, de la partie du passage, of the part of the passage, de laquelle ils se serviront, of which they make use. In fact, you'll have noticed as we go through these things, there are words that crop up are just identical between French and English. So don't be frightened. There's a surprising amount you're going to see straight away. Another interesting thing in French, here, you'll notice in the English version of the conveyance, we dealt with all the boundaries. Then we had a totally new clause talking about rights. Here, the right is buried in the middle of the boundaries. In other words, as they went round the boundaries, when they got to the point where a right was relevant, because here was the side of the property where it happened, they put the right in. There was a logic to it. But it does mean when you're looking at a French conveyance, you've got to read the whole thing, because things that you might expect to be in one place couldn't pop up in another.
I mean, I had a shock the first time I read one of these through, and I thought I'd mistranslated because I was finding servitudes popping up in the middle of it, and I'm thinking, I got that wrong, didn't I?
Yeah,
Of course I got it wrong. So that was a little bit of a shock, because of course I'm not used to these.
And then we come to the final boundary, I suspect, here we are, and we lie to the west, Morbihan, thereabouts, of land, terrain, it's not so different. Appartenant à la dite société Flock Investment, so the developer again. And again, although we haven't got a defense en bois, we don't know what it's made of, we've got a fence again, la défense entre deux, appartenant de ce bail, belonging to this sale. Then we move to it's kind of, it's difficult, we don't really have the equivalent of this in English. It's sort of a bit like the warranty of title and the declaration of where the vendor got his title from. They're kind of mashed up together. So it says the said sale and all it carries or it contains with its ins and outs, its walls, its liberties, its franchises, its servitudes, all as may vest and belong, competir et appartenir petit
And where's that-
bailleur.
Where's that? in con-
Sorry?
Where did you see all of that?
Competir,
Okay, okay.
what does it mean?
Yeah, I'm going a bit quickly now.
Zero passing, what's that mean?
Literally as may competir, vest, be held, belong. There's no direct word I can use. It's that notion of the utter ownership. Yeah. Belonged to the vendor, preneur avant, so it was a purchaser by way of a prise avant of the premises of this sale from the said company, Flock Investments. Suivant, following, literally,
yeah.
or by is the easiest way to translate it. Contrat, nothing about conveyance, it's a contrat. Enregistré, registered on the, and then they say it in words, the 26 avril, 26th of April, 1900, 63. Then another big difference with a French style conveyance. Prise à robe. It says the whole thing was made for the price and sum of 254 papiers, 3 bosseaux, 1 dinar et 1 quint de froment de rente. So you took the sterling price and you converted it into quarters and bushels of wheat. So we've got 254 quarters, 3 bushels, 1 denarii and 1 quint of wheat rolls. The froment is wheat. Froment is wheat, of wheat rente, que le dit bailleur a reconnu et confessé avoir présentement vendu. So which the said vendor recognizes and confesses having presently, literally now, sold, vendu, alienated, and completely transferred from himself and his heirs. Again, we've got this notion, enfin et perpetué d'héritage. So forever. To the said purchasers, accepting for themselves as far as they're, again, this constant repeating of the same principles following through. So the price which was owed by the purchasers was, and because you could only transfer land by way of creating a rent, so, okay, here's a big issue in Guernsey conveyancing. I think I mentioned it in the guide somewhere. In origin, all transfers of land were exchanges. What you did was you took the land, the immobilier, you exchanged it for another immobilier, a rent. So you swapped them over. So the purchaser now held the land, the immovable. The vendor in exchange, he had a different kind of immovable. So whilst the land is an immeuble corporel, the rent is an immeuble incorporel. So it's an immovable, but it's intangible. This is quite sophisticated financial engineering. So there was no question of consideration, cash being needed. The contract was valid because you'd exchanged immovables. There was cause. But in the very next clause, in this particular case, and most modern conveyances of that time in the 60s, the deed font that said sale, made for the price and sum of, and now we've got something all of us can understand, 5,200 livres sterling, £5,200 sterling. Oh, if we could buy a house today for £5,200 sterling. Oh, that was a lot of money. These were nice new houses in a very nice place. Yeah. It goes on to say, qui le dit bailleur vendeur, which said seller vendeur, a reconnu, effectively acknowledges having presently received in good money accounted for, in other words, are the equivalent of the vendor acknowledges having received, from the said buyer acquireur in his hands, for himself and his heirs, from whom and themselves, the survivor of them and their heirs, the said sum of rent, the 254 quarters, 3 bushels, 1 denar and 1 quint, which they had raised as a rent due on the property, demeura amorti, shall be amortized, redeemed, enfin et pour jamais, fully, forever. So they instantly, they raised the rent, they kept faith with the method of exchanging land in Guernsey.
And then we got rid of it.
Then the purchaser immediately redeemed it, and it was gone. So it was, in fact, free of rent.
Is it just like a theoretical thing then?
Yeah.
Because we don't do it anymore.
Yeah. You could still convey land by creating a rent. The law says you still can. You wouldn't do it. No, they don't
in
need
the
to.
60s, did you have to?
No.
Why would you do
No, but because the way
Because conveyance is in French.
because
Am I right
the
in saying-
contract
Oh,
because
contracts.
the contract was a prise à rent.
Mm.
You could only buy land by a prise à rent.
That's what I mean. This is the only way of doing it.
Correct.
Yeah.
Correct.
And then,
Strictly speaking, if you didn't redeem the rent in full, this contract would be called a buy a rent.
Okay.
It would be a sale for a rent rather than a purchase for a rent. As I say, if you look at the 1969 conveyancing law, it sets out in very brief form some of the old terminology, and it takes all the lovely old distinctions about prise à rent, buy à rent, contrat d'échange, de licence, and it simply sort of smashes them all and says, oh, they're all called conveyances. Oh, great, thanks, guys. But that's what this is doing. Sorry? That's the 1969 conveyancing law. Yeah. The one that allowed you to draft in English. Didn't say you had to. Just said you're allowed to. Then it carries on. To whom, auquel dit preneur, to which said purchasers and their heirs, and here we get a sort of second bite at the warranty. And their heirs, the survivor of the two of them, the said le dit bailleur, the vendor, promises and is obliged, a promis et s'est obligé de fournir et de garantir le dit bailleur, to literally furnish or provide and to guarantee the said sale, guarantee le dit bailleur, et la dite vente et amortissement, so the sale, the buy, which is the sort of, to describe it, it's the ancient exchange part of the sale. The vente, that's the sale part involving sterling cash, and the redemption, and to hold the said sale, et de leur tenir le dit bail, and to them accurately, hold the said sale. So this is a promise being made to the purchasers. Quitte, exempt, free and exempt, de toute rente, all other, if strictly speaking, it's all other rents, whatsoever, quelconque, save, sauf, chef rente, assieu, we just say chef rente today, it's chef rente assieu, so it's a chef rente due to the seigneur. Et droit seigneurial dues, we now call them just manorial dues, sur l'obligation de tout ces biens meubles. Ah, interesting. So the guarantee is in personam. And that's why in modern conveyances, we say, here it's called the vendor, which expression shall, where the contract shall include, and you limit it to heirs, They're not giving the guarantee on property, they're giving the guarantee personally. So tout c'est bien meuble et héritage, even they called them then meuble et héritage, what they really meant was meuble. Présent et futur et décessoire.
So what does that mean? So l'obligation de tout bien meuble et héritage?
Strictly speaking, what I know it looks like a promise made on the heritage, but
It does,
I'm not convinced you could have. Oh, actually, no, I'm going to change my mind there. Yes, he was basically giving a guarantee of title on everything he owned. Yeah,
That's what I thought that.
yeah. Sorry, it's in modern day that we don't regard that as being valid anymore. It's now just in personam.
It's all this movable.
Everything he owned.
Everything he owns.
Yeah. Literally present and future, and all his heirs. Yeah. It was more extensive in a sense.
Yeah.
But in 1969, the agreed, you'll see there's an agreed translation of what that means. And we, the law ordered that now would be expressed as, and it's in the way we now express it. So that, in a sense, was commuted down to a simple personal obligation.
And then you couldn't buy direct, like what?
Well, any promise you give in personam binds your personal estate.
So would
So your heirs end up liable to pay your debts and obligations out of your personal estate.
I thought that's what that did, was put the liability in your
It does, yeah.
Yes.
Yeah. But here they're saying it applies to heritage as well.
Yes.
So
Yeah.
theoretically, it was against your real property.
Yes.
But if you say now, is your real
No. So the promise that you give your guarantee of title in a conveyance contract, however you want to describe it, that's now in personam only. You haven't given any obligation against your.
And that was changed by the 69 laws.
That was 69 that changed all that. Yeah.
But if you had debt, it would have to come out of the state first.
Yeah.
Until
But
that was
that's
distinguished.
that's part of succession law.
Yeah. But then, is the property safe or could a creditor?
Theoretically, I suppose if you had a judgment against somebody,
But I thought you went against the movables.
you always go against the movables
because
first
that's the
anyway.
debt,
Yeah.
so
Yeah.
that's a seated with the debt.
Yeah.
Yeah. And then, yeah.
Yeah.
Yeah, you always go after. Yeah.
You have to exhaust the personal estate first.
Yeah.
Yeah.
I can't remember. Is that an ordinance of? Isn't there? Oh, I see the customary law, and then it was put in an ordinance. I can't remember the date.
Yeah.
19. Oh, I can't remember.
Although the heirs are council, they move out council, they could after it.
They could theoretically then continue against the real property. I think what the 69 law tried to clarify was there was always confusion as to whether that was an immediate charge against your real property.
But it's not.
But it's not. No, certainly not today. If it ever was, it was always a big.
They moved that down.
Yeah.
I never thought it went. You went. I always thought even at this time you went against movables.
Oh, you did, yeah.
Yeah. Sorry.
Yeah, but when,
I'm just thinking.
No, I'm all right, thank you. I'm going to just my taxi's 10 past 2, so you don't mind.
No, it's fine.
and then we move to the equivalent of the possession clause. A, that's an easy word to translate. And. Entreront les dipreneurs. Of course, French has it order of the words the different way around. So, and entering into possession, the purchaser shall enter into possession. En jouissance, that's possession. Jouissance is possession. Of this present prise-à-rente, here's an interesting one. It wasn't that day. Le 26 avril courant. The 26th of April. Courant literally running, in other words, this present month. And, another A, on produit, having produced un congé. Ooh, the good old days, congé. And the congé, by the way, was a genuine piece of paper signed by the dame or the seigneur that you had to produce to the court. Having produced a congé from Dame Elsie May Lenfesty. There's a blasted Lenfesties again. Get everywhere.
No, it's not common good.
Yeah.
Well, it's not massively common, but it's very ancient. Yeah. Elsie May Lenfesty, but of course she was wife of Lawrence Gill, founder of Monsieur Lawrence Gill. But she was the Dame of Fief-le-Comte. Tell you what, she lived very nicely with all the congés she got on these developments.
Really?
2% of every price. Every time a house was sold, she got 2%.
Congé isn't a piece of paper, but it's actually due.
Yeah,
No,
it
yeah,
is,
well,
it is in the notes as well. Yeah.
You actually produced a piece of paper which declared that the congé was granted. But
But it
you then
wasn't-
had to pay the seigneur or the dame the 2%.
Yeah.
They'd only given it on the basis you, the advocate, undertook to pay them the 2%.
Was it 2
Yeah.
And it had been fixed for so long that no one could remember how long ago it had been fixed. We're probably talking early 15th century kind of fixing. No. Yeah, for here we go. Oh, this is really interesting. Okay, right. Now the congé was produced for 34 quarters, 1 bushel, 1 denneral, and 1 quint of wheat rods, which lesquels congés portaient acquis du 13e, which said congé discharges liability to pay 13e. 13e was the true entitlement of the seigneur, 1/13 of the purchase price. My maths is terrible, but that's something close to about 8%.
Yeah.
And it then explain, sorry?
That was still paid.
Sarkit was still called 13e, but you paid a congé of 2%.
Oh, right, okay.
No, sorry, no, you're right. You paid the 13e, yeah. Yeah. So the seigneur was on a wonderful income. Yeah, blasted human rights law, got rid of it.
Really?
How did they get rid of the
They had to have an ordering council, which took away many of the seigneurs' rights and powers, which is the Sark Chief Pleas Law, or whatever it's
I
called.
know something this up, and then in Guernsey, you've got all these
Oh,
congé,
well, they said it occurred so long ago. If you read Peter Jeremy's evidence, they questioned him about it. And they said, do you mean that it is time out of mind? And he said, well, yes, that would be a good way of describing it. It was so long ago, no one can remember when we stopped paying 13e and started paying the congé of 2%. But it has been like that for so long.
and how was the 2%?
No idea. No one knew.
No, but how was the 2% removed from 1994 till now?
No, it's not, it doesn't exist now.
Doesn't exist
Doesn't
now.
exist.
So how is it taken away?
The abolition of congé law.
Okay.
Round about. There was the original law in the 1990s, and then there was the final laws and ordinances in 2003, off the top of my head.
How do they do that? Because, sorry, this is probably completely fine. That's somebody's property right to receive a rent.
But an ordering council can take away.
No, I realise that, but.
Because, I mean, if people can't be very happy about
Yeah,
it.
I mean, yeah.
Well, the seigneurs weren't massively happy, so the compromise was reached that there would be a phased withdrawal of their right to claim the congé. So I think for a period of 5 years, they got 50% and the states got 50%. So it wasn't suddenly we've abolished your property rights. It's,
It's like, you know, the landlord, if someone said or something.
Yeah.
I can't have your rent.
Yeah.
Well,
Yeah.
Yeah.
but that's the power of enacted legislation.
Mm.
You can enact any law you like.
Yeah.
You know, if
So presumably there were more people in favour of abolishing it than
Correct.
than not, so
Yeah.
that's probably,
Yeah. so that there were maybe
The public voice probably
it actually affected about a dozen people
versus.
versus 60,000.
But it is fundamentally removing your property right.
Mm.
Yeah.
That's
Yeah.
quite a draconian
Right,
step.
no, exactly, that's what I'm wondering.
There you go, the power of the modern state. But it finishes with something interesting, because it says that the congé was only for 34 quarters, 1 bushel, 1 dinar, 1 quid. The whole price was 254. So how come it was only on 34 quarters? Aha.
Mm.
Next clause tells you the answer. And, good word, it being, it literally, there being no congé, or there being no need to produce congé, the besoin de congé, pour les 220 quartiers de boisseau, which is the bit that's gone missing, of the froment de Lente, of wheat-born, remaining restant du prix de ce bail attendu, literally almost attendu que, almost well understood. Although that's not what it translates as. I think almost because this purchase, cet acquet, effet is made dans l'an et jour, within 1 year and a day, de l'avant dite prise à vente, of the previous purchase à vente, par le dit bailleur, made by the said vendor, and when congé et que congé pour pareille somme fut alors produit, and when congé for the same sum was already produced. One of the things the seigneur couldn't do was claim congé twice in the same year on the same property, only on the increase in price. So there was a saving where property was quickly flipped. Just a quirk of the customary law.
Because some of that, I mean, I don't think that's difficult to translate, but I do think it's difficult to understand.
Yes.
Does that make sense? So,
Yeah.
so the
Yeah.
French, I don't think it's that bad.
Other
So,
than time pressure.
yeah, but I think
It's one of those things that unfortunately only time will make you good at it.
Yeah.
And once you've got a grasp of it, it's, to me, that would take about 2 minutes to
Yeah.
read and get
yeah,
everything.
I agree.
I don't think a lot.
I agree.
But you're used to seeing.
But I'm used to seeing it,
The
yeah.
way it's set about.
Because it took me a long time.
And it's more the concepts that underlie everything
Yes.
that's being said.
Yeah,
That's
that's
harder.
right. Yes, I agree. The translation I don't think is difficult, but I think, and you know what I mean, you can translate sometimes, but you don't necessarily understand.
Oh.
And there's a difference between
Yeah.
translating and understanding and just
I
translating.
always used to make the point in my that literal translation does not work.
No, it doesn't.
You need to understand the
Yes.
sense, the
That's
context.
right. That's right.
That's harder. And,
Yeah. Yeah.
No shortcuts, I'm afraid.
Thank you.
Thank you. I shall see you all again on end of March, and I'll try and work out, or try and get the information as to how many hours that. Also,
I think it is a day.
I think it's a day, but-
Short.
It's been really